April 23, 2024.
Do a roll call.
We do a roll call.
Yeah.
Stickert,
Here.
Sherrick,
Yeah, here.
Miller is absent. Long,
Here.
White, Barton,
Here.
Bidoff,
Here.
Shireman,
Here.
me.
Here. Public participation. Seeing none. We're going to table the minutes from the last meeting. They're not done yet. Discussion of this meeting, 2000 International Property Maintenance Code to 2024 International Property Maintenance Code, and the creation of the Bucyrus Property Maintenance Code. We're on page, Mr. White made some registries. Everybody's got a copy of them. They look pretty decent. I'd like everybody to look over them. If there's any changes we want to make, then we can make them next meeting. Is that okay with everybody?
Sounds good to me.
Good. So we were on page 5.
6.
Now we're on page 6. Is there any changes that you'd like to make?
On 103.06C, every dwelling entrance shall have the correct street number of such dwelling prominently displayed so that it is clearly visible at all times from the street in front of the property. I think entrance needs to be removed from there because you have side entrances that you don't necessarily want to be required to have a street number.
So you'd like to take out front entrance? Front of
Just
the front.
eliminate entrance. Just say, every dwelling shall have the correct street number.
Okay. Everybody okay with that? Take out entrance, everybody okay with that? Okay. We are with 103.07, access and egress. Uh, 103.08, unsafe structures and equipment. Let's go on to page 7. Anything we need to add or take out? Yes.
I guess this is probably where it's going to get a little dicey, because going back on page 6 to 103.08 and going forward, what's the qualification for the PMO to determine what is and what is not a structurally sound building?
We really haven't got the PMO yet and their qualifications. And it's touchy because we can't afford an engineer.
I agree.
We can't afford to have, the city cannot afford to add anybody to that position.
Yeah, and so I think procedurally, I mean, we can go through this, and I know that there was some discussion about splitting out, and trash, rubbish, grass, weeds, that type of stuff would be, you know, your typical, and then everything else we would have to hire an engineer to do. But procedurally, so if I file against, based upon something that Mr. Grove has come upon, or what, however, your first step is the appeals process, right?
Yeah.
And the appeals process, you're going to come in and question the authenticity or the, the credibility of anything, right? So that would be your first say, well, how do you know? And you're going to bring plausibly your construction guy or whomever does your structural stuff, and he's going to say, if I say we said that it was 50%, the value of the building was less than 50% of what it's going to cost to repair, which the code refers to if the repairs are going to cost 50% more than what the value of the building is, then it's considered condemned, whatever.
I've heard that 5, 6 years ago,
That's
and I never pursued that, but is that actually printed someplace?
Yeah.
Is that, and where would that be?
It's in the 2012 International Property Maintenance Code.
Okay.
So, under the condemnation portion, one of the ways that I can bring a condemnation action would be that the value of the structure is less than 50% of what it would cost to repair those. So, at that point, we have a factual argument, and you're going to say, I can repair this for $25,000, and the building is worth $80,000, and you're going to bring in a contractor or somebody that says, yes, these are the repairs that are necessary, and they would suffice to repair everything that you're concerned about, and the auditor says it's worth $80,000. You don't have to bring in, you're going to bring your evidence to show me why Gordon is wrong, and if we, Gordon or whomever, and if we proceed as the city, that would be one on a case-by-case basis that I may have to hire outside engineering to determine what, to meet those qualifications. Say that you don't appeal it and we go to court, and I'm trying to prove on one of these structural issues that you fall under the code. Well, I have a burden of proof beyond a reasonable doubt that your house or this structure meets that, whatever that is, that it's unsafe or uninhabitable. I'm going to have to prove that, and one of the issues is going to be competent, credible evidence. And so, at court, you would attack the qualifications of my expert and vice versa. Right. So I understand that there's, what are the qualifications of the property maintenance inspector and those types of things. But by and large, the code makes that a legitimate argument throughout the process. And I think that the office, it would be very easy for anybody to come in if they had their inspector and I just drove by on the street and said, yeah, that looks like it's a dilapidated building not capable of being repaired. It would be a credibility and a sufficiency of evidence type thing. And so rather than trying to say, well, the property maintenance inspector needs X, Y, Z, D, elemental P, all of these, those are things that are going to be sorted out and vetted throughout the process. And I guess that's all of these things that we're contemplating and discussing. You have checks and balances through the Appeals Maintenance Board, through the Board of Building Standards and Appeals, and then through the court system. You also have the right civilly to file injunctions and say, you guys are completely wrong, and they're trying to force me out of my habitat, or they're trying to force me to, whatever, and they're wrong. And so I'm filing an injunction to enjoin the city from trying to enforce bad law, and then we get in a fight between your expert and my expert. I think this system is set up.
Because I have living proof that this doesn't work. Okay, I have property here in town. This is during the Ratliff era. Okay, so I'll start there.
We have to be careful. We don't want to get off basis of here. We can't have our own stories in it. So can you explain it as far as the property maintenance code without putting your own stories in it? See what I'm saying?
Without what? Without what, please?
It's this is a property maintenance, so this is what we're discussing, so I don't want to get into any personal stories because we get off the subject of the property maintenance code.
No, that's fine, but at some point between page 7 and the end of this thing, it's got to be brought up. It's an issue.
It's an issue, yes, and I believe a fix to that, to help that issue is if our current PMO says that your structure is unsound, then that brings us a dollar value. It's going to cost you money to prove him wrong. And it's going to cost us money to prove that that structure is bad, is in violation. So there has to be a money structure in here. If you would win on that, then I think the city should be liable. If the city's
Well, that's
wins,
definitely not in this code.
I know, but I
Okay.
would like, before the end of all this, I would like to address that. And so if the PMO is going to say your structure, somebody's structure is bad or unstructurally safe, I want to make sure he's right, and he better be right, or it's going to cost the city. If he's wrong, then you have to fix your problem. See what I'm
Mr.
saying?
Gurn, would that even be enforceable? Read some kind of language in the code? A penalty phase, I guess, or a penalty amount? I can't imagine that.
Oh, you could put liquidated damages in there, but I would have to look at that. I never contemplated that specific setup. I don't know. It's interesting.
See what I'm saying? If you've got a $50,000 property and you're saying it's going to take $25,000 to fix it, and you take this person to court and say, okay, now he's got $5,000 in trying to protect that $50,000 property, I don't think he should be liable because the city accused him.
If I'm accused of rape, pillage, murder, and I pay $150,000, $200,000, $300,000 in attorney's fees, and I'm found 100% not guilty, short of malfeasance, misfeasance, bad acts on part of the prosecutor's office, or bad acts on the behalf of the investigating agency, I don't get a dime of my attorney's fees or my reputation back.
But you can, well, your reputation, yeah, but you can still sue them, right?
I have to prove bad acts. I have to prove intentional, willful, bad acts. And by and large, I mean, there's a significant amount of immunity on the city. It's got to be really heinous, outside the ordinary course of, I mean, basically targeting.
Okay, that may not be something we can do.
Okay, all right, well, not to slow the process down, I guess I'd like to make a statement that I'm okay if we move forward and we talk about what PMO can do and all that, but sooner or later, I'm going to assume we're going to talk about qualifications of PMO, and you know, I'd like to address that then.
Yes.
So, and I can talk to you offline. I can tell you, you know, why my horns are up right now. So I don't want to slow up the group though, because you know, I can give you case study why what we're talking about is a problem. But I'll move forward so we can go through all the nitnoid here.
Okay. Our PMO is, let's say he's an electrician, I don't think he can come in and say you're structurally unsound. He has to bring in an engineer to say you're structurally unsound.
You're saying up front?
Pardon me?
You're saying he needs to do that up front when he let's say worst case he condemns a house.
Okay.
Okay, tomorrow morning they go out and condemn a house. Okay, when does he have to have that
Engineer.
proof? At what time?
I would say if it was a structural problem that he was going to do that too, then he needs an engineer to come in if he's not qualified to be an engineer.
And that's my
Structural
point. That's
engineer.
what I'm saying. As it is right now, we're not going to fix this in the next 10 minutes. As it is right now, PMO can go out and condemn a house tomorrow, and then the owner spends the next 4.5 years trying to remedy that.
Okay.
And, loss of rent, all this work, and the bottom line is, I'll wait,
But
I'll say that.
PMO is on the list, I believe it should be. Okay. All right, anything else on page number 6? We're done with 6. We're on to page 7.
Under the 103.08 unsafe structures and equipment, the E4, when any portion of building or any member, appurtenance, or ornamentation on the exterior thereof that is not of sufficient strength or stability, or is not so anchored, attached, or fastened to in place so as to be capable of resisting natural or artificial loads of, it says, 1 1/2 the original designed value. Shouldn't that just be the loads of the original design value, not 1 1/2? Oh, is there an explanation why it should be 1 1/2?
I'm not sure.
So it seems to me if you've got a 2x8 going across the floor, and it shouldn't be cut over 2/3 if you're running a soil pipe or water line or something. I'm guessing that's why it's 1 1/2.
Well, I mean, it still should be capable of maintaining the original design value.
Yeah, I understand what you're saying. This should be hold, if it was constructed up front originally using industry standards, then why, when we're investigating at a later point, is it have to hold 1 1/2 of what it was originally designed to hold? That's what you're saying.
Right.
That makes sense to me.
It should just be the original design value,
Should
not
just be
1 1/2
the-
times.
Yeah. Yeah, because if it's originally designed to hold 1,000 pounds, now why would it have to hold 1,500 pounds?
Right.
Okay.
What does it say in the property maintenance code? I'm sure that's touched on. Is that taken directly from it, or?
Yeah, I'm not sure. I wasn't able to find that specifically in the, I was looking through the 2024. I wasn't able to find it there. I didn't even bring that with me.
I think what you're looking for is in the 2012 code, which would be under section 304. Under 304.1.1, unsafe conditions. going down to number 7. It says exterior walls that are not anchored to support or supporting elements or are not plumbed and free of holes, cracks, or breaks or loose or rotting material are not properly anchored and are not capable of supporting all normatic loads and resisting of all loads effects. It's the only thing I can find that refers to that. It's on page 12 of the code. And basically, it talks about unsafe conditions, basically talks about all about loads on the roof, the exterior, the interior, walls, ceilings, floors, walls, and everything, about structural members.
So, yeah, my interpretation of that is just that it isn't required to hold more than the design value.
Yeah, it only talks about the evidence of deterioration, not capable of safely supporting nominal loads, so there's nothing that says it needs to hold more in 2024.
Okay, good then? So it would just be original loads, right? Okay. We're on 8 now? I got nothing on 8. Anybody else? On to 9.
Mr. Chairman,
Yes, sir.
under M, appeal, maybe some better clarification there as to the appeal, who receives the appeal. Says any order of the PMO under this section or any section herein may be appealed within 10 days of notice the violation to city council. Should we go to the law director maybe instead of city council?
Yeah, so those appeals are going to be heard by either Property Maintenance Appeals Board or the Board of Building Standards Appeals. I don't know, whatever that one's called.
Yeah.
Building, whatever, you know, it's BBSA. So yeah, I assume that, I think that it would be appropriate to have those, any appeal filed within 10 days or however many days you want to give at the law director's office.
Right.
And then we would set it at that point.
So they should go to the Property Appeals Board, and is 10 days enough? Do you feel?
I think the current code gives you 20 days, but I would also, so there should be, the point of contact should be the law director's office, and then it's on me to get the Property Maintenance Appeals Board together to hear this appeal.
Okay.
And I don't care how many days you give them, but.
Yes.
As somebody mentioned, you know, it's 20 days right now, and my experience with that has been good, because let's just say Gordon gives you 10 days to fix something. Okay, well, for some reason that the two don't mesh, then you have time, you still have time to go to the appeal and then go through that process. So I would make it at least 20 days, because some items are 10 days, some items are probably 30 days, and that 30 days, in theory, you could do your work, he doesn't like it, and you've lost your right to appeal.
So let's just go 30 then, right?
No, it should be more than 30. If he gives you 30 days for a semi-major, item, then if that's the same 30 days as the 30 days for the appeal, you wouldn't have time to appeal.
Okay. Yes.
Brian, does the appeal start upon you doing the work or upon your work getting stopped, like that doesn't work for you anymore? Like we're not
Yeah,
going to
your
accept
appeal would
what you're
start
doing?
As soon as I give you notice of a violation, then but, so I'm not sure I understand the time frame that you're saying, but you could just track your appeal. You have within the time frame allotted for your repair, so you can either make your repair or make an appeal, or simultaneously.
Or simultaneously
Well-
do both?
Right.
I think what Mr. Long's saying is, if we fix it, then he comes back and he doesn't like it, then would he reissue that?
Yeah, I get what you're saying.
Then the appeal would start, right?
Mr. Chairman?
We would, yes, in those circumstances, if you're making an effort and you've done a significant amount, or you've brought in and showed us that your contractor is going to, this project's going to take 40 days, we would issue you an extension. But I understand part of Mr. Long's goal or objective was to limit discretion of the code enforcement officers. And so giving me or anybody discretion to issue extensions, I don't know.
Mr. Long?
I guess probably the simplest thing we could do is, because some of the violations are given 10 days, some are given 30 days, at a minimum, it probably should be 45 days for the appeal. That way, we're way past the Gordon time. And I want to preface all this too. I'm not trying to be adversarial here. And with the current law director, I've had violations. I fixed them. It's not been a problem. I've been given extra time. So this is not a lick on the current law director. I'll make that very clear to everyone. But I've had that experience with previous law directors and overzealous PMOs at times. So I think if we're going to go through this, we should make it like if we had the worst case scenario for that relationship, rather than, right now it's good, okay, but it could change. It could change with a different person.
So you're saying the PMO comes in and says you're in violation, you go ahead and fix it within 10 days, let's say, and he comes back and said, no, that's not good enough.
In theory, it could be. 'Cause
It could be, yes.
Okay.
I can see that.
So that's why that appeal process is good, because you still have your day. You have your day in front of a group. Your day in front of a group. Where if you're chopping this thing down to the same day or whatever, that's not. I don't think that's healthy for the process.
Mr. Stucker.
I think initially on the beginning of the Property Maintenance Appeals Board, when we had violations, notice of violations sent, the 20 days to appeal that initially was if the recipient of the notice of violation didn't see any recourse of getting a extra time to do the repairs, any satisfaction from the code enforcement officer or the law director's officer to have more time to make the repairs, that 20 days was effective right then from the receipt of the notice.
Yeah, so I think that you could put in here, in the event that you're issued a 30-day notice, you have 45 days to appeal said notice, and then under that 903 point whatever the section is B, in the event you're issued a 10-day notice, you have 15 days to appeal. I don't want to give you 45 days to appeal picking trash up out of your front yard,
Oh, no, I agree with that.
you know, or mowing your lawn, like, those are.
That's what,
Okay.
This may help also. Let's go back to the 30-day example first. Given 30 days, and let's just say it's January, can't do the work outside, or whatever the case may be, all right, and so the law director's office gives you more time. At the end of those extended periods, that's when that appeal time should start. Whether it's just the original 30 days, or if he's generous enough and gives an extra 30 days, and maybe now we're in February and it could be just as bad. I'm worst casing this, but we need to. We live here in Ohio. We have things like that happen. And so at the end of his appeal, or I'm sorry, at the end of his extensions, that's when that time should start for, say, 20 days to appeal, in my opinion. That way you don't lose that.
So you see what he's saying? He's saying 20 days, then the appeals should start after that. So if the PMO gives him 20 days to fix it, and he's not fixing it to the PMO's request, then he should have 20 days after that to fix it, or to appeal it. Yes.
Right. His argument is based on differences in opinion.
Yes.
Based upon the actions taken after notice is given, not differences of opinion in what the underlying issue is in the first place.
Yes.
Well, in the example of the 10-day notice, something small like, say, trash, okay? Once again, 10 days goes by, and worst case is January again, or something like that, and it, for whatever reason, doesn't happen. Somebody's in the hospital, somebody died, whatever. Whatever amount of time the PMO / the law director would give you an extension, at the end of any and all extensions, you should still have at least 10 days to go do the appeal for that. If it's a 10-day violation, it should be at least 10 days after your extensions are over. And in the case of a 30-day extension, it probably should be at least 10 days or 15 or whatever after any extensions have been granted. Because just because an extension has been granted doesn't mean we're all going to be happy with each other at the end of the work.
So what's that? It's like page 9, section something.
M.
I think that's probably one of those things where I spent some time, put together some more detailed language rather than, there you get a 10-day appeal process and then bring it back to you guys. I don't think that it's tonight.
Yeah,
is going to-
Yeah, something to be more precise of what the violation is versus how many days of appeal for each one.
Right, and there's going to be different,
Yeah, I agree with
different
that.
timeframes, different types of appeals. If you're appealing the original, I tell you that you have to fix the pole on your porch is falling off, and you say that's not even a structural pole, I don't need to do anything with it, it's a whatever. So if you're arguing or appealing the underlying issue, there may be one set of rules. If you're appealing the fact that I've now repaired it and you still are picking on me because it's not right to your standards, but it's fine, a different set of appeal period. I get it, I don't know. I'll look at it and spend some time thinking about those.
Yeah.
Okay.
I'm very satisfied. Thank you.
Anything else on page 9?
Chairman?
Yes, sir.
I've got a note here, I don't know which paragraph it concerns when I went through this, but I think it'd be good for everybody, including the city, if after the violation is corrected and the PMO is happy, that we get a sign off. That way, we can tuck that in our same file, that, 123 Main Street, whatever violation there was, it's done.
Doesn't the PMO have that on? I mean, he starts a case on everything, right?
Yeah.
And he should
So yeah, I don't,
give a note that it's fixed or something.
right, right, we'll throw that, yeah. Some language I will bring back to you guys about, yeah.
Okay.
If it's
Thank you.
satisfactorily fixed, we'll provide notice. If it's not, I don't know, we'll provide, I mean, yeah.
Good with 9, everybody? We good with 10? Move on to 11? So on number 11, it says on 105.01, the PMO and/or all inspectors assigned by him shall enforce the provision of the code. The PMO shall have the authority to adopt and propagate policies necessary to enforcement of the codes to the appointed inspectors and agency. What is that in there for? I mean, he's propagating, he's changing stuff to.
I would take that out.
Thank you.
Necessarily, whoever's administering it is going to have some discretion and some policy.
So-
I don't issue a policy. I don't issue grass violations in the middle of a 3-week rainstorm. Well, it says if you're above 6 inches, I got to. Ooh. We're going to have some policy. I think that that's probably sort of superfluous language that's going to create more headaches than.
So 105.01, policy-making authority, we're gonna strike that.
Yeah. Does that include at the very last sentence?
I was gonna say,
'Cause that's way too open.
The PMO shall have the authority to interpret this code.
I would get rid of it all.
You read the whole thing.
well, you kind of have to have something that states that he can bring in other inspectors though. Because if we did need something else, he'd be the one that would have to bring them in, wouldn't he?
Well,
Yeah, but he's just going to do that because that's part of his job. Like, we always, I mean, if the auditor needs, we're not experts in every field, right? So we are always hiring, and there's money in the budget. So like in the law director's office, I have money in the budget for outside contracts. I have money in the budget for outside legal places. The property maintenance, if there's an issue and we're doing something structural, we're going to plausibly have to bring in somebody that can give us an expert opinion on any sort of issue. I don't think that the code specifically would have to authorize us to do that, just to be able to do that. And I can hire agents and hire accountants and all kinds of different things, simply in the exercise of my authority.
So you would do that, that wouldn't be the
Yeah.
PM up?
Yeah,
So that not one person would be making this decision, it would be,
yeah, it would be run through. Gordon's not going to, or the property maintenance inspector's not going to authorize the expenditure of any funds without, it's my budget.
right.
He's under my budget, so it would all come out of the exercise of my authority.
So we all good with taking that out?
Mr. Chairman,
Yes, sir.
are we done with that part of it?
Sure.
I'd like to back up to the rubbish and waste control, 104.01, accumulation of rubbish or garbage. The all exterior property and premises and the interior of every structure, carport, deck. I would like to add porch in there and patio. Porch shall be free from. And then also in 104.03 refrigerators, I would like to add on to the end of that, all such equipment shall not be stored on exterior property or premises for more than 10 days.
I think you need to add a word in front of that, shall.
I'm sorry?
You should put the word shall before not, shall not be more than 10 days.
Well, that's what I have written here. If I did not read that, I'm sorry.
Okay.
Yeah, all such equipment shall not be stored on exterior property or premises for more than 10 days.
And I would say too, Ohio Revised Code has a prohibition against, they call them abandoned refrigerators, but no person shall abandon, discard, or knowingly permit to remain on premises under the person's control any abandoned, discarded icebox, refrigerator, or other airtight or semi-airtight container, just because kids get in them and can't get out. But
Yeah, well, I was giving 10 days to allow them for arranging for the removal of it.
With or without doors, you want them?
Definitely just.
Yeah.
put outdoors.
With or without, they should not be stored
Okay.
outside more than 10 days at all.
I thought they had to have the doors taken off immediately, like,
That's
They
what
should
that
be.
says.
yeah,
yes.
so without doors, still no longer than 10 days.
Right.
Mr. Chairman, do we need to get more specific, similar equipment?
Yeah, I was thinking that too, like washers,
Washers,
dryers.
Well, yeah, I did have actually to put in, instead of similar equipment, put
Television.
other appliances or equipment with doors and/or lids.
Glass.
I don't know if you want to go to that extent or not. but-
I guess they narrowed that down to refrigerators in 104.03.
Miranda's got it. She wrote it down.
I guess they thought in similar equipment would cover anything with a door or lid.
Well, major household appliances.
Well, it could be about anything. I mean, maybe some guy has a parts washer in his garage or something, you know,
Or a
pretty
trunk.
big size, or a trunk or anything like that, you know.
Rewrite that. Says you can rewrite that.
There you go, Miranda.
Yeah, so we could throw some descriptive information, so, refrigerators, washers, dryers, dishwashers, freezers, chest fruit, whatever,
Yeah.
and then, so throw in the ones that we can all think of off the top of our head and similar such, televisions, similar such things. I mean, that shows what we're getting at. If a court were to interpret, well, what are they trying to put here? Oh, those things that can trap the individuals, those things that are, large, and can't be used in your front yard. There's no purpose for your washer to be sitting in your front yard.
Well, the
I haven't
idea,
seen anybody run an extension cord and a hose yet. God, now someone will do it.
You said it out loud.
I did.
the idea as I interpret it is safety. You
Yeah,
know,
for sure.
so it's to make sure that kids can't climb inside them and get trapped and suffocate, whatever.
For sure.
But essentially, I know that people, their appliances go bad, so they get a new one and they set the other one outside. Well, yeah, that's okay, set it outside for a brief period of time. That's why I said maybe 10 days to allow them time to arrange for disposing of it.
Usually they're gone 1 or 2 days when they set them out front. Yeah, yeah, they do. I mean, I've seen them sit out for maybe 5 hours and there's a truck or whatever, a trailer, they're picking them up for the scrap.
Yeah.
Why can't
Some
we
people don't.
specify any large, unworking appliance, no more than 10 days?
That could be too.
Cool, that'll work. Yeah, but usually if you set them out in between the sidewalk and the curb, they're gone that day.
Mhm.
People scrap them.
Yeah, there's a guy over off of Spring Street.
And then he's up in somebody's front
I
yard.
think the problem is though, they want to scrap it themselves, so let's keep it out back until I get more
Yeah,
stuff.
this guy just keeps piling on that trailer until his trailer gets full and then he hits right over. I know where he lives and you can always tell him, call him, go to his house, say, hey, there's a bunch of crap here, he'll go right over and pick it
10
up.
days.
Mr. Dyer.
10 days.
Huh?
Mr. Dyer.
I think it is.
Yeah, he's helped me out before getting rid of
He,
stuff.
all you have to do is go knock on his door. If not, leave a note on his front door and
Yeah.
just give him the address and like 2-3 hours or whatever, he's over picking up anything and everything that he can scrap. He's a very nice gentleman.
Page 10.
Back to page 10. You backing up to page 10?
Yeah, I had something on here that
Okay.
I marked. And it was salvage materials. I'm not sure why it's in here. It's 103.12 demolition, and it's under C, salvage materials. C, I got a check mark here.
I think that was to allow for salvaged material to be accessed, was it, or? Yeah, I read that, I forgot. Oh. I think that allows, like, the city to obtain this salvageable material and
From a
sell
demolition.
it. Yeah, from a demolition.
So if we have to demolish it, then we would be given the right to salvage materials from it to help with the
Okay,
cost.
I understand. So if the woodwork is real nice woodwork, then they can sell that to somebody.
Yeah.
And put the money in.
We really need that in there
He's
because
got to leave.
I do know that they tear these houses down and a lot of them say it's not worth their time.
Yeah, they just
But they have to have the right to do it if they can.
take a backhoe in there and do it. Yeah, we'll leave it in there.
It's in there just because if we need the right, we would have the right.
Okay. So we're on to 12? As far as records, Gordon Groves keeps pretty good records. He keeps pictures and everything.
Yeah.
I talked to him
Yeah.
a week ago. Yeah, meticulous. He was showing me some of the stuff.
Yeah, and they're retained according to our retention schedule.
How long is your retention schedule?
I knew I shouldn't have said that. Probably for that stuff, 7 to 10 years. Don't quote me, but I think it is probably 7-ish.
So violation and notices, section 107. Doesn't 53, 2023 take care of that? Violations and notices? It turns stuff into a...
So, yeah, that's a good point. So then, that section, what is that, 107? Taking what we have and taking what 53-2023 did, and then combining it in a cohesive, this is your notice requirement language. I'll bring that to you. So that we have rather than having, part of the code has a little bit to do with notice, and then this part, so you have to read a couple different, it will all be condensed and placed in one cohesive unit.
And we can keep 53, 2023.
53 will be, it'll stay in there.
Yes.
But it'll be kind of sort of superfluous because this language is 53, the language that we wanted will be in that now. So that you don't have to open up the code and look one place to figure out what's going on with that and then run over to this and figure out a different thing.
Perfect.
Notice it.
Everybody like that?
Yes.
I mean, it's difficult when you don't have something all-inclusive, and you have to look here to find that, but except in these circumstances, or but subject to that. So the more comprehensive that this is, the easier it's going to be for everybody moving forward.
I would probably go down to 107.02 because this is a civil offense. It's mentioning civil offenses. page 13. Everybody good with 14? Corrections, violations?
On the 107.03 hearings, middle of the paragraph, get the right.
The appeals board?
The appeals board shall conduct a public hearing on all civil violations whenever the person charged requests a hearing. The hearing shall be held within 10 days after the filing of the request. I think 10 days is a little too tight there.
Yeah, what,
Change that to 20 days?
and so what are the rules on how far in advance they have to be advertised?
Yeah.
I know for plating, I have to do 30 days.
Right.
Oh, it's 24 hours.
Oh, for appeals board, it's 24 hours? Okay.
It's like it's a Board of Zoning Appeals or anything.
So it's 10 days of...
Just with the experience, though, the
Yeah.
10 days is a little bit tight to try to set it up and contact everybody and make sure they're, you know, they have time, the time available for the meeting.
What would you suggest?
20 days.
You have the experience in it.
Let's see. And also in there, let's see, in the next paragraph, I think it's the next. Yeah. The appeals board shall not have the authority to extend the time for compliance with any provisions of this code for more than 60 days. With past experience, we have granted longer time due to the season, winter,
It is Ohio,
and so forth, yes, yeah.
so 90 days?
I think 90 days is what we've used in the past.
Okay.
And then it was dependent on extenuating circumstances, again, due to weather or whatever, so.
Tornadoes.
You can't get your shed built because of the tornado.
Mhm.
We saw that today all over.
did add some nice skylights.
Oh, we were at the Board of Zoning Appeals, and the gentleman had some issues with whether getting his thing built in the time he thought it would take him.
Right.
It was interesting, the tree down was probably 150 years old, but it didn't blow his building down.
Right?
He was within 100 feet of the tree that blew down, so.
Mm-hmm.
It was a little building, just wasn't in the path.
Moving on to 15. So 53-2023, it doesn't say civil offense, does it? It's a, what is it?
Criminal.
It's a criminal offense. So we have civil offense all the way down through here. It's mentioned that's all got to be changed. The
Right,
criminal-
just like where it says village.
Yeah, there's some of those
Yeah.
cleanup things.
Yeah, polishing.
Well,
3.
it also says throughout city solicitor instead of law director.
Yeah. So I'll go through and clean that part up. I think that you do want to give some ability to proceed on the civil docket as opposed to the criminal docket. Because right now we're running into situations where people are living in abandoned and dilapidated homes. We know they're living there, they don't have water accounts, they're throwing trash in the backyard. That pile of trash is now 8 feet tall. And so we've declared it a nuisance building, which you give 30 days to evacuate, and now that they haven't evacuated, but they don't, I mean, it's not their property, they don't have a lease, they have no right to be there, so it's a quasi trespass, but the police department says, well, we don't know, the owner hasn't said they're not allowed to be there, well, the owner's dead, those types of things, that's a different argument. But some of the civil remedies would be filing, basically to have them evicted. So I think maybe part of this is the ability to proceed and ask for a court to order us restitution of property and some of those civil remedies. As, I mean, a criminal remedy would be jail time, fines, those types of things. Civil remedies would be giving us possession of properties, giving us the right to manage and control those, evicting people, boarding up properties. So I think we, well, I'll look at that, but I think there has to be some ability to proceed with
both.
Yeah, with non-criminal sanctions.
Yeah. That's for 107.08, so
Yeah.
civil proceedings.
Right. We don't do it very often, because typically we want compliance, but I can think of like 4 houses right now that have got squatters living in that I really can't criminally prosecute them, and I would just want them out and to board up the house.
Page 16 is the same thing, violations, penalties, administration regulations. Yeah, this is easy, got violation penalties on it. It says a civil citation into the following amounts. This is 107.99.
Mr. Chairman, I have a question about that one.
Yes, sir.
Where it says first offense, second offense, third offense. That kind of sounds like it's 3 different violations. It's actually just one. It should be like first warning, second warning. It just reads kind of funny to me.
I think that's where Mr. Gernert needs to polish that up a little bit.
But it's all one offense, right? It's just 3 different fines,
Usually give them 3 chances to clean it up.
right? But they say first offense and then second offense. Sounds like it's a separate offense to me.
I think if they don't do it after the 3rd offense, the city will come in there and clean it up and just put it on their taxes. I think it's been past practice.
But what I'm saying is it's all one offense, basically. Right? They get warned the first time, $100. They don't pay that. It's $250. Am I reading this right?
The warning doesn't usually come with a fine. I think that's what they're...
Yeah, so I'll look at, I understand what you're saying.
You see what I'm saying?
Yeah, and
Is it
that's
3
not,
separate offenses, or is it just one?
and that hasn't typically been, we've always attempted to obtain compliance, not penalties. So, you know, right now I can send you a notice of violation and you clean it up and we're all good to go. And so,
One offense.
is that an offense? But if I send you a notice, because this code also talks about, well, providing notice and an opportunity to cure. So if I provide you notice and you cure it, and then later you do the same thing, are you now on your 2nd offense? And if you don't cure that one, we're up to 2. There's a bit of meshing that I have, now that we've opened this up, that has to occur so that this part of the code meshes with the back part of the code. And if in the front of the code you get notices of violation and an opportunity to cure, but the second time, no, we're going to fine you, you know. And I'm not in love with the idea of the city issuing civil citations for monetary, I mean, I don't know. I always like to have, I mean, if you're going to get fined or something, have that go through a court.
Mr. Chairman,
Yes.
yeah, in that section there with fines, under the A, B, and C, the above fines are cumulative,
Cumulative.
and each day that a violation continues after that date for remediating the violation has passed shall be deemed a separate offense.
Right.
So if you get the notice and you don't clean it up and they come back out the very next day and see that it's there, that's a separate offense according to this definition.
Mm-hmm.
I guess that kind of answers my question.
I mean, that doesn't really allow enough time between violations for them to get the problem.
So is there any, what kind of verbiage can we add in there to?
Yeah, I'm not sure.
I think you ought to leave it up to Brian.
And basically, you're just going to throw something in there that says a violation, anybody that's issued a notice of violation and fails to cure within the allotted time may be subjected to civil penalties For the first offense, it's gonna be $100, second offense, $200, or whatever it was, third offense, $500. And then you throw in the cumulative language, which says each day that you haven't fixed it is a separate offense. And in reality, it's sort of monopoly money. What do I do if you don't pay me? I can't put everything on your real estate taxes. What if you're the tenant and you don't own it anyways? I definitely can't put a trash rubbish on the landlords who didn't do it. So I have to think about that. But I think you definitely would have to, prior to giving them any civil citations for monetary amounts, you definitely would have to give them a notice and an opportunity to fix that prior to any penalty provisions. I mean, I guess you wouldn't have to, but it seems sort of archaic if you don't.
So it'd be one of those, your next offense would be if you were given 10 days and you didn't do it in the 10 days, that first day after the 10 days, here comes that next offense.
So the way it's written right now, day 11 is your first offense, day 12 is your second offense, day 13 is your third offense.
Right.
No, we don't do that.
But was that the
We do
part
have
that you
budgets for
put in
all.
there specifically that helped out the landlords because that gave them something that they could then grab onto? Okay, you've decided to make these offenses, I couldn't do anything about it, but now I can use that to evict you. Because I thought that was one of the things that he was trying to do was put in something that made it, if it is a rental, then now the landlord has something that they can use. Okay, now you've gotten to this, I can't do anything, you're not doing it yourself, so now I can use this as a way to ask for your eviction.
Plausibly, but.
But then, it's just the wording needs.
Right. And then you run into the, if it's just a trash rubbish type case, the magistrate in Crawford County, there is, the law, his interpretation of the law is you're required to give him a 30-day notice, which is interesting. So almost all leases, I violate Jim's lease, he gives me a 3-day notice, whatever. But even if in my lease it says I have to keep that property in a clean, orderly fashion, whatever, compliant with all state local laws, there's something in the Ohio revised code that says on those types of evictions, I have to have a 30-day notice. So then I can't necessarily give you a 10-day notice and start fining the landlord on day 11 if he doesn't have the ability to access and restore that property until day 30. The magistrate was talking to me about that the other day.
If a person has trash and rubbish and they're on their first offense, they clean it up,
Yeah.
they're fined $100, whatever. A year later, same thing. Is that called first offense again, or does it go to second offense? That's where I'm having
That
trouble
would
with
be unclear the current way it's written.
That's where I'm having the
Yes,
trouble with
so
the
that would be
offense.
So we need to clear that up.
something that, I mean, I think that.
They could argue, well, no, that's my first.
That is my first offense. I cleaned it up last time you saw
Right.
me. And we do that. We have that argument all the time. Well, I got a notice and I cleaned it up. How am I in court? I already cleaned this up. Well, you cleaned it up on this day, but the next year it was whatever again. So, yeah.
And they say that's my first offense.
Right.
I think that goes back to what Mr. Long was saying about a notice given to property owner or the tenant that the violation was corrected.
Yeah.
Okay, so once they get that notice of correction, and you're saying the offense happens a year later, then the law director has legal grounds to say, no, this is your second offense because here's your letter that you received noticing that you did correct the problem the first time. That's why I think Mr. Long was adamant about that letter of violation, that it was corrected, be documented and given to the property owner, the tenant, or whoever involved, that it was done for legal purposes.
I think we're kind of getting into the repeat offenders
Yeah,
situation here, though.
yeah.
Uh-huh.
So if you give somebody a notice, let's just say to clean up garbage at their property, does that have a number on it?
Like notice number 1?
Like notice 101?
Mm.
This 101 notice.
Just got a
and
date.
It's just got a date on it?
So to say, April 23rd, 2024, under the International Property Maintenance Code, which has been adopted by the City of Bucyrus, you're hereby notified that your property fails to comply with Section C, trash, rubbish, weeds. You have until May 5th to remedy this issue, and then we slap some pictures of what we have witnessed. Because we always, every complaint, Gordon actually goes out and verifies. We don't.
But Gordon keep that in his record, first offense, second offense, third offense.
We haven't historically been documenting that, but we could, yeah.
So, say January 1st, he goes out and takes pictures. Does he go back and check on that property and make sure that they did clean it up within the 10, 30 days?
If you have January 1st, you get your notice, or we send out your notice, and you have January 10th, on January 11th, he will go and take more pictures.
He will take a picture, so that
He will.
picture has a date on it and a time on it. So that problem has been taken care of right there. Okay,
Yeah.
so now if he has another offense with another set of tenants at the same property, then that's actually documented that this is a different offense through his pictures.
But we may or may not know, yes, that you have a new tenant.
Well, it doesn't even have to be a new tenant. So
Same tenant.
Same, let's say it's the
But
same
should
tenant.
you theoretically get a second violation if your first violation was based upon your tenants and now you fix that and now your second set of new tenants have done the same thing? It goes back into the landlord-tenant issue. Is it really?
But all I'm saying is, he took pictures of the problem, now he's took pictures of it's cleaned up.
Right.
Now that citation's over.
And yeah, and what Mr. Long says, which is probably a good idea, is that we send you a notice that we've re-inspected and you're good to go.
I think that'd be a good idea.
Yeah.
Yes, ma'am.
Why can't they put first offense, citation, approved, and the date?
Okay.
And then if you have a second violation, that's a new one, then once that violation is fixed, then under that you write second violation approved and the date.
That second violation doesn't have anything to do with the first violation. Is that
Well,
what you
then
mean?
that is between some way to put it in an agreement, a new tenant.
Okay,
That's the problem.
cool. That works.
There's something to think about.
It's
Then you also have
wording,
a time frame, so if your property in 2019 was, you were taking care of your beloved mother and your weeds grew up and you didn't get to mow your lawn, and now in 2024, it happened again, is that now your second violation 5 years in between and we've never had an issue? I think that there's probably some clarification that we would need to throw in there about timeframes, violations, durations, including some language in our notices, so we're all a little bit on the same page better.
Well, I think that kind of should be discretionary with the code enforcement officer and law director's office in communication with the person receiving the violation.
Yeah.
I mean, if they communicate and say, hey, yeah, this happened again, and these are the circumstances, then you be discretionary with that.
Yeah, I would say probably 50% of the cases, somebody has issued a violation, they call, they talk to Gordon or myself, we go back out a month later and it's, okay, everything's good, we move on. Just the ones that don't get compliance are the ones that everybody sees.
Hey, Jim,
Yes.
looking at the rest of this, to page 21,
Yes.
is this all stuff that he really needs to clean up before we look at it?
Well, this mortgagees, the thing we're coming up on next,
Yeah,
I really want that in there because.
right. I didn't know how much that we should mess with before he gives us more of the legalese corrected.
So first, let me ask him a couple questions.
Okay.
So it's-
Mortgagees.
Yeah.
So I like that part of it because I think that's somebody that's gonna foreclose on a property, which is a bank,
Uh-huh,
and they need to register with the city
uh-huh,
that they're foreclosing on it.
okay.
And I really like that section, 17 and 18.
Uh-huh.
But it only has to do with mortgagees, right? Or banks,
Right,
or lenders.
I understand.
So to get somebody in
Yeah,
Arizona to register that property is gonna be a trick and a half.
yeah,
But
but at least we have some provisions to attempt.
if it's a foreclosed property, we can always catch them at the sheriff's office.
Maybe, well, yes, maybe.
Could we add a document to that to say, hey, you've got to fill this out too? Whoever you are buying for, or if you're here buying for yourself, you need to fill this paper out. That way we can track you and you're taking care of that property.
Mhm. And then you get the cases where they have foreclosed, but they don't take the property back. So I foreclose, I end your whatever, but I never go to sheriff's sale because they don't want the property back in their name, because then I can come after them. There's properties in the city that are in the name of the person that was evicted and foreclosed 5-10 years ago, but the bank just let it sit.
Okay, so the bank never put it in their name.
Right. It's something to do with their accounting, and they don't want to be liable for us, to us, and to other issues.
If it doesn't go back to the bank, then in their name, how do they control evicting the people that were in there or keeping them from going back in there?
Yeah, and in those circumstances, sometimes they don't. They literally just went to, for the, their SEC regulations, the regulators that come in and look at their books, they just want this property off their books, but they don't want to own it. They just want to
Dump it.
dump it, kill the mortgage, wash their hands of the property, and walk away.
So it's just a paper trail. If somebody stays living in there or not, they don't care.
They do not.
Yeah. Okay.
It's the zombie properties, and then
So we have to let the taxes mount up on it and rely on the county to foreclose on that property.
we do,
Yeah.
oftentimes.
And they have no set criteria on how to foreclose on that property.
That was my question. Is there a way to put in here a set criteria? If you foreclose, you must, I mean, it's hard to go after them still, but at least then we've got something in our regulations that says, so that they don't turn it into a zombie property?
Yeah, and that's it, or at least provide us, the city notice, add us as a party to the foreclosure or something, so that we have a little bit of ability to manage it on the front end. It's not as bad, but that was a huge problem after the 2009 bubble burst, and all of the banks were foreclosing a ton of properties, but they didn't want to own a ton of properties. So
Yep, 2003 and
walked
2004
away.
too.
Yeah.
For
They have an
for
initial registration fee is $500 for foreclosed properties.
Mhm.
I could have sworn in the open projects you had a vacant property registration
We did.
that was drafted up.
It
Was
has
that,
been.
would that have anything to do with this?
It would play into this in those instances where a property has been foreclosed and the bank did retake it, I guess, yes. And so if a bank takes it over, and a lot of this applies, it's just then, in my mind, the circumstance where it's in the name of one person, but they've moved on because they've been foreclosed and went to do something else. And now it's sitting in their name, but the bank doesn't want it.
So can we add a form to the sheriff's auction to say, hey, you have to fill this out and register this property with the city? I'm not real, I don't know if we can add a form to the sheriff's office and say, well, when you have this property that's coming up for foreclosure and everybody's bidding on it, here's an extra form for them to fill out. And it's a registration for the property. And that registration's gonna cost them $500. And that's gonna go into our fund for abandoned houses.
Right.
Mr. Chairman,
Yes, sir.
I have another question. With everything being said about the mortgagee, can't we put something in here about the lender? To where, you know, if the lender's not going to come back and purchase, you know, take over the house, can we put some kind of language in here for the lender and go against the lender?
Well, that would be the mortgagee, because the definition of mortgagee is.
Right, I was reading that. But,
Yeah, so the mortgagee is the guy who's
right,
giving the money,
right.
lending. Maybe we can throw mortgagee, lender, all of those superlative words in there. But yeah.
Yeah, and I think there needs to be a little bit more defined, you know, definition of what the mortgagee
Mortgagees, lender.
is. A definition of that mostly is what I'm looking for, is just a definition of that word. Because I think that might take notice to some people that whether you're a private individual or an LLC or a bank or mortgage company or whatever institute, there's a clear definition of what mortgagee, a private investor.
I was reading an article on City of Cleveland. They had a bunch of these zombie homes, and the council actually passed an ordinance stating that they had to have somebody within the city, no matter where they lived, the owner, the mortgagees or the lender, that they had to have somebody in communication within the city of Cleveland to take care of the property, contact information, so they could get a hold of everybody.
I thought we had that in this. I remembered reading in here that there had to be somebody, was it, in the city that.
I can't remember if it was in this one, but it's in something that I read. It's not hard. It was required to have an agent with a local address.
Page 19.
Right here at the top.
109.05 is maintenance obligations of mortgagees.
So at the top, the mortgagee shall notify via no in writing the property is transferred to a bona fide owner or occupant or unaffiliated third party.
Cool. Just because it's in there doesn't mean you're gonna get them.
Yeah, that's what it says, the form, yeah.
Right, so yes, the U.S. National, not U.S., but U.S. Bank, Wells Fargo, they're not going to comply. I mean, maybe if you get somebody that's good at a local affiliated branch, we might be able to get some compliance, but.
So if they don't do the initial registration, we can put $500. Well, we're gonna get the properties anyway, so.
Yeah, I mean, the thing is, the only way you could do it is put a particular fine, and then, as it was brought up before, if they don't comply, that they don't find the property, they find the bank or corporation, and let Brian here make it a criminal case and bring them into a court of law.
Okay. Okay. Well, that brings us to page 20.
Mr. Chairman, I'd like to back up just real quick here.
Sure. Where you want
On,
that?
Page 16, 107.10, ex parte communications prohibited. A person may not communicate with an appeals board member to influence a decision in a matter pending before the appeals board other than at a public hearing or in a writing that is made a part of the record of the proceeding.
Okay.
That kind of limits a appeals board member, restricts them from going out and looking at the property or looking at the violation and communicating with the person there if they would happen to approach them.
So this deals with more of a person approaching a board member. So,
I just don't think that they should be restricted from communicating as long as they do not try to persuade or sway the decision of the appeals board member. But just a matter of discussion of the issue, I don't see that as a problem.
Right. So that portion you would either have to keep in or completely delete. Because if you can try to put something in there saying we'll have no discussions attempting to influence an official's business, then, well, no, we weren't talking about that, and then you get into and so, you know, like, judges, an appeals court judge or any judge isn't allowed to investigate this matter on their own. That's what you're sitting and you're presiding over a hearing, and the city would have to present their evidence as to why this is a violation, why this remedy was not appropriate, why whatever they did to fix it didn't work, and then the landowner would come over and say, present the other side and present evidence, and so basically all of the evidence that the appeals board would be considering was that things which were presented, sworn testimony under oath in front of them. A judge or a jury could do a site visit and say, okay, now we've heard all of these evidence, and we're going to go look at the property, and then we'll issue our decision. I guess I understand what was intended. I don't feel strongly one way or another. I know that
Okay, well, I
in a
just
small
know that-
town, in a small town, you're going to drive by half of these houses, and what am I can't really prohibit you from looking at it. In a perfect judicial system, you would have no knowledge of any of this, and it would all be presented in open court or in open appeals case. But that's not realistic, so I suppose just deleting the ex parte is the more manageable system. And then if I have to, as the city, I think that, Mr. Mr. John Doe has improperly influenced you, then I bring it up at the appeals board and say, well, isn't it true that you guys went to dinner last night? Isn't it true he bought you a 30-foot yacht last week?
Yeah.
I know where that yacht came from. Yeah, but it's not a perfect system.
Okay.
And trying to limit that is just going to be unmanageable anyway, so my opinion would be get rid of it.
Right. Just in my experience with the appeals, a lot of the information just isn't there beforehand. So I go out and I look myself.
Right.
to see
And you're
what the
a
situation is.
appeals board if I don't like what you did, I have the ability, not you personally, but the board, if I don't like what the board did, I have the ability to take that to court. If the person, owner doesn't like what the appeals board does, they can take that to court as well. So the final remedy is a ignorant court that hasn't, ignorant in the sense that they don't know anything about the case, they haven't seen any of the pleadings, heard any of the arguments, and it's all fresh review. So I think it's fine.
So do you want it out, Bill?
I recommend taking it out.
Is anybody opposed to that? So we'll take it out. Got that?
Yep.
Well, seeing it's 7:30 and we made some headway today.
I make a motion to adjourn. I'm not allowed to make
He's not
motions.
allowed.
I've had a lot of fun.
I'll make a motion that we adjourn.
You got that? Everybody, boys?
Okay.
Yes, ma'am.
Well, I was just gonna say, wouldn't you like to announce when the next one would be? That way I'm not calling 9 people.
I'd rather have you call 9 people. But, when's the next one, Miranda?
So probably can do it May 14th. Be a reasonable amount of time for you to clear up any language.
I like it.
May 14th.
And a 9-board quorum too, or a 9-person board, 5 people is a quorum, so.
Okay.
5.
5? 5?
It's on Tuesday, ain't it?
Adjourned at 7:37.
Oh, you don't.
We adjourned at 7:37.
7:30.